The Supreme Court, which has today in a unanimous decision ruled that the birth certificate is not proof of citizenship. The court also says that the certificate is not a form of identification. The document is currently used as proof of citizenship in application for Ghanaian passports, but the Apex Court compares it to the NHIA card, which it rejected prior to the 2016 election and concluded that, quote, the birth certificate is actually worse, end quote. This was contained in the full written judgment of the court in a case filed by the opposition NDC and private citizen Mark Techi Banson. The court on June 25 dismissed the request to stop the EC from compiling the new register of voters or allow the use of birth certificates and current voters' ID card. Now, as you know, the court deferred its written judgment to July 15. We have secured a copy, and my colleague, Joseph Akable, joins me via Zoom with details of that ruling. Joseph, first run us through why the court rejected the current voters' ID card. We understand additional reasons have been offered in the judgment.
And so the first reasons we get from the court is that it says there's evidence before it that confirms its belief that indeed the processes leading to the award of those cards to individuals were not done in accordance to law. In fact, it says there were instances where individuals were issued with those cards despite not showing proof of identification or providing a document that proves that they were indeed citizens. And they make reference to a training manual that was issued by the Electoral Commission for its officers, which they make the point that they should not insist on documents that show citizenship in registering Ghanaians. And so the court said that was evidence that indeed it is a case that there are individuals who registered without having the required document. And so if that is the case, then the existing voters card cannot be trusted to be used as a document to carry out the exercise. We again asked the question about whether or not the EC's actions and the decision not to use the card has resulted in individuals who otherwise should be on the electoral roll from not being allowed a chance to be on the roll. And the response from the court was to the effect that once they've taken that out, all other individuals who want to register have the same platform. All you need to do is you need to meet the requirements and show up at the registration center and be able to get onto the electoral roll. And so it's concluded that the EC's decision is not arbitrary, ruling that the existing voters' ID card should not be used.
Now, Joseph, let's talk about the birth certificate. What reasons does the court give for its view that it does not show citizenship?
The first is to the effect that there is nothing on the birth certificate that links to the individual who holds it. And so when someone is holding a birth certificate, you can't say for a fact that this is Araba Commission's birth certificate, because as you can see with the other documents, it doesn't have the picture feature on it. The second point it makes is that it is a document that does not prove citizenship, and in fact it compares it to the NHIA card and makes the point that the NHIA card is actually better and that this card is actually worse. And so on that basis, it concluded that the birth certificate cannot be used as a card of identity, one, and number two is that it does not show citizenship, and the third point being that it cannot be used to carry out the registration exercise, which requirements are that one, you must show that you're a citizen and you've attained the age of 18.
Joseph Akable is my colleague there with details of that Supreme Court ruling. Well, private legal practitioner Ernest Kofi Abochi shares his view on this development.
No, let me just say, first of all, that I think the decision is rooted in pragmatism, the decision itself. So this is a decision whose outcome may appear to be informed by pragmatic considerations. When the original voters registration was adopted, indeed when the Constitution was adopted, I don't think the framers contemplated that a time will come where forensic and biometric registration may be invented, or so to speak, and may justify or necessitate and render outmoded a previous register that may have been adopted. I don't think that was, and I think therefore that may have been overtaken by time, which has created the situation we have today. Mm-hmm. But the reasons that are contained or were contained in the decision, the reasons that have been given by the court, some of them are a bit difficult to rationalize, with the greatest respect to the justices, and a great deal of respect.
Which of them do you have a difficulty with?
Well, I think you just mentioned the issue of the voters, the birth certificate. Mm-hmm. The birth certificate has been accepted for a number of reasons. I mean, for all kinds of things, identification purposes, for all kinds of things. You cannot get a passport of Ghana unless you have a vote, unless you have a birth certificate. So if you can be given a passport which is recognized as one of the modes, and the originating point of a passport usually is the birth certificate, but the passport as the end product can be accepted. However, the birth certificate, which indicates your lineage. In fact, if you look under the Constitution, the factors of citizenship, the birth certificate contains those factors. The issue of birth, the place of birth, the issue of the parentage. All these are contained in the birth certificate. So the decision is what it is, and at the moment, it is the law of the land. But the rational decisions and the rational reasons that have been advanced for them, again, with the greatest respect to the justices, some of them are difficult to justify, so to speak.